you know. All right, good morning, everybody. My name is Patrick with Stewart Title. Sorry about the 5-minute delay today. We found out Zoom is the go-to for the builders. So now we know, now we're on track. Everybody should have a folder in front of you. It's got a list of some upcoming events that we'd like to draw your attention to. So here in this room, and hopefully on Zoom, we're going to have a cryptocurrency class as well. We're going to have a lawsuits class, and then we're also having our Done for Charity event this Thursday. So be sure to check those out on RSVP if you guys would like to go. On the left-hand side is a corporate brochure that talks all about who we are, where we're from, what we do, and why you guys should work with us. Before I hand it over to Roberta to go over the class, I figure we'll go around the room and introduce our Stewart staff that's here. So Chrissy, I'll hand over to you.
Good morning, I'm Chrissy Patterson, a Business Development Officer in Stewart at our main office in Reno.
Andy Guest, Business Development Officer, also for Stewart.
We're all from Stewart.
Hi, I'm Kelly Bradshaw. I'm the Senior Escrow Officer at our Pleasant Gate office.
I'm Roberta Crown Rogers. I am in escrow and leadership.
That's Stewart.
I'm not at Stewart. I'm Carol Pope. I'm the attorney that is going to fill in.
I'm going to educate you today.
I'm Michael Ittner. I'm brand new, just started 33 years ago. So happy to be here with you guys today.
And in our back corner there, we have
Kenny Fontes at our Mayberry office.
Amy Kronberg, escrow officer at Mayberry.
Stewart.
All right. So everybody's contact info, including their emails and their phone numbers, are listed in that corporate brochure. Their systems are in there as well, so you can get hold of us at any time if you have any questions. And with that, I'm going to turn it over to Roberta and Carol and let you two take it away. So thank you guys for being here.
Thanks, Patrick. I'm going to keep my water close. Thank you guys for being here. We appreciate it. This side or that side?
Which side?
So really quick, I just want to do another little commercial because for Stewart. How many here have had an opportunity to work with someone with our company? So we not only have a phenomenal escrow staff, some of us are here. We have a few offices here in Reno. As you heard, we have Plumgate, which is on Plum Lane in Arlington. We have our Kitsky office. And then we have a beautiful new office, again, where Amy and Danny work with some other fantastic escrow officers over in Mayberry Gardens. We have a Person office, we have a Gardnerville office, we have a Fernley, Winnemucca, and then Elko does have an office. It's under a different division, but still Stewart. We have a fantastic title department on site. A lot of experience in that department. And for any of you who've ever had any kind of commercial transactions or complicated transactions, you understand how important it is to have that support here and local and accessible. We also have customer service on site. Melanie and Spencer, they're amazing. And customer service doesn't even begin to describe their turnaround and how wonderful they are. So please, if you haven't had an opportunity to try us out, please do. You will be pleasantly surprised. Lots of locations, lots of a great team we have. So you guys are here for our trust class. And I've been teaching this. I kind of created this several years ago when I was at a different company. And it's just kind of grown. Carol's helped me a few times. It's so nice to have her here because she can talk about things that I can't because I'm not an attorney, but she is. So some of you might have some burning questions that will come up that she will help tackle for you. So how many people in here have a trust? Okay. And how many of you have done a transaction where your seller is vested in a trust? And you know that the title company is going to ask for a copy of that, correct? Have you ever had that situation where the title company hasn't asked for it? Okay. So one of the things, and one of the things that I'm here to kind of talk about is to give you an explanation so that you can share with your clients
why we're asking for that information. And then part of what I do in this section of the program is explain the components of a trust. So when somebody establishes a trust, whether it's an individual or, you know, married people or anybody, you don't have to be married to each other to establish a trust with another individual. You are establishing the trust and you're conveying your assets into the trust. It becomes sort of a different entity. The basic components, the people that are transferring their assets into the trust are going to be referred to as either the grantor, the settlor, or the trustor. And then part of what the trust encompasses is the ability to administer the estate. Hey, how are you?
Wait.
That's
I got
okay.
mail. Nobody knows.
There's several reasons why people establish trusts. Carol, why don't you talk about some of those?
Sure. So one of the reasons, but the basic reason that most people establish a trust is to avoid probate. I mean, you know, 'cause that is not the most fun process, although I really like, from an attorney standpoint, I really like to do probate. So, but when you're going through it, it's not as much fun. So before I talk a little bit more about the trust, you know, with the probates in Nevada, you want me to chat about probate for a little bit?
Yeah, you, absolutely, sure.
Fine, okay. So there are like basically three levels of probate. There's a set aside probate. So if the value of your estate is under 100,000 and you have real estate, you can do a one-time petition, you can get it set aside, and that's really quick. That'll take like, you know, depending on where you are, what county you're in. I mean, it might take 30 days to 45 days to be able to transfer title to the property. Because I mean, that's what, you know, we're really hearing. How quickly can you transfer title to a property and sell it and take care of that? So in the event that the net equity is under 100,000, which would be taking the value of the property and the any money over on the property, you could do a very quick petition. But most of the time, when you're dealing with real property, you're either in a summary administration where the value of the estate is 100 to 300,000, or you're over 300,000. And in that scenario, it's going to take 6 to 9 months, if you're lucky, to get through a probate. You can go ahead and sell real property during the probate, but that is, again, another expense. You have a petition you have to file. You have to set a hearing date to, if you're not doing an independent administration, which is a whole other thing, but set a hearing date. And so you have all the expenses associated with that. So getting back to why you have a trust, if you have a trust, you can have your successor trustee sell the property as soon as possible, takes over right away. You don't have to wait the 6 to 9 months. It's normally with summary administration or general administration, you're looking at a cost of anywhere from probably 7,000 to 10,000 to probate. If I create a trust for a couple, you know, it's generally about 1,500. And to do the trust package, which would be the certification of trust, the trust agreement, and then you still each have a will, which is probably one of the most confusing things I have with people that try to do it on their own. Like I have one right now where they did their own trust. They went online, got the little, you know, program, did their trust, decided, oh, I don't need a will. Well, then this particular decedent never transferred her assets into the trust. Her checking and savings accounts didn't go into the trust. But now I have no will that says if an asset needs to be probated, it goes into my trust. And so now if an asset needs to be probated and there is no will, it's going to go according to what our laws of intestate succession tell you who's going to receive it. So the bottom line is it's great to have a trust package. You avoid the probate, and that's really the reason why you get a trust.
And I'm gonna jump back in here too. One of the things that seems to be kind of confusing for people in some of the classes that I teach, having a will is a completely, if you have a will, that does not mean you don't need a trust. It's a different estate planning document. The difference, if you have a will versus if you don't have a will, determines whether you die testate or intestate. Carol just used the term intestate. If you die intestate, that means you don't have an estate planning document, and how any assets that you have are administered is removed from any control you have. However, it still requires a probate, will or no will. If you don't have a trust, but you have a will, you still, and you die, that will require a probate. It just will be determined as to what kind, based upon some of the things that Carol just discussed with you, asset amount, et cetera. So talking about, again, from the title company standpoint, if you have a client that's vested in a trust, and let's say they haven't died yet, we went straight to death, man. This is a dark class, but that's okay. From a title company standpoint, if your people are still alive, you're going to want to let them know that the title company needs a copy of their trust. And for those of you, do any of you guys in here pre-open transactions? And you know what, y'all know what I mean when I say pre-open? You take the listing and you start title work. I know there's a lot of controversy about that because there's certain things you can't say in the listing remarks. But from a very fundamental perspective, pre-opening a transaction is very useful, especially if there are issues that show up in the chain of title that are problematic. That gives us an opportunity. And I'm not talking about the people that pre-open them and just say, oh yeah, I'm going to promise you this escrow, but the title company doesn't do any work or start a prelim. I'm talking about where you actually tell us, please start a prelim on this property. I'm listing it and I want to have the work started. And then what happens or should happen is that your title company, your escrow people should get that report, review it, and communicate with you if it's good, if it's not good, who's entitled. For instance, if I have one and there's a trust involved, I send it out. I say, hey, Kyla, here's your prelim. It's vested in Carol and Roberta's trust. And there's 2 loans to pay. Other than that, it looks clean. Or I say, hey, Kyla, here's your prelim. There's judgments. There's IRS liens. It's a nightmare. Let's talk. Let's start working on it now before you get into contract, because those things happen. And it's a lot easier to have, start working on that before you're in contract and you've got all the other pressures and deadlines of that contract. So just kind of a side note about, why pre-opening is a good idea. And just, again, kind of off the topic of this, I know there's, again, some controversy. A buyer may want to use a different company. And that can happen. That's okay. Obviously, partly if whoever's doing the work on that transaction, we'd like to have that escrow and be able to see it through to fruition. This notion is about building a partnership, not just the one-off, oh, we didn't get this transaction, so forget it. Sometimes those things come up, but it's still a useful tool to have that information ahead of time and start working on it. So that being said, what happens is when you hand over or your client hands over their trust to the title company, our title department reviews it, they approve it generally, and just they acknowledge these are the people that pursuant to the trust. The trust itself is the governing document for the assets that are in the trust. And to Carol's point about moving over to briefly again over when somebody does pass, the way it works in our state to this point is in a trust, you can list all your assets, and that's great. You have 10 properties and 10 bank accounts and they're all listed in the trust, that's perfect. You also need to physically convey the assets to the trust for them to be considered, if you die, as being not needing a probate. So if you have only 5 properties that you put in the trust, and there's 5, and when I say put in the trust, I'm now talking about actually have deeded into the trust, and 5 that are not deeded, then those are subject to probate, even if they're listed in the trust. Does that make sense? So it's really important on that note, because a lot of times when some people refinance their properties, the lender will require that they come out of their trust, that they get deeded back in. I've had transactions close where I had that happen, where I had someone sell a property a few years ago. She said, yeah, nope, this property's in the trust. It was one owner, an individual, that had a trust but had refinanced the property and had come out and died, and then her successors, her heirs were trying to sell the property and had to go through probate. So a really important thing to remember really for yourselves too, if, as you're embarking potentially, or if you have trusts, that piece of it, if somebody's asking you to deed out, make sure it gets deeded back in. And if that's happened for any of you recently, feel free to give us a shout and we can take a peek and make sure how you're vested if you'd like. So, did you want to say that, were you going to say something about that or?
Oh, yeah, there is a way that we still would have to do a probate action, but if you at least have listed all of the assets that you intend to be in the trust on your, then usually you have a Schedule A. I can now do a one-time petition and get it put into the trust. But if you have no Schedule A and it's out of the trust, it definitely is subject to a probate. Yes.
Okay, so on that, if you have the 5 houses in the trust, deeded in the trust, you have 5 houses not in the trust, but in the will, there's the language saying that any other items not encountered in the trust will get moved into the trust. Are you then doing that Schedule A petition, or do those items have to go through probate still, and then they get moved into the trust after they go through the probate?
If you, so, you know, like for what I do for my trust now, I generally list the properties individually to make it clear. And I do have like a catch-all, all real property. And it's the trust document that's got to have an attachment that says, this is what I intend to have in my trust, like all bank accounts, all vehicles, you know, all real property. And if you have that schedule and it's dated and signed by the creator of the trust, then yes, I could do that one-time petition. And it would then take those properties and put them into the trust.
But it still requires a court order.
It requires a court order. It's less than if you had to go through a whole, like in that scenario, it would be a general administration and it'd be a long time to go through that. It's a one-time petition, but it still does require a court order. That's why it's super important that you make sure you deed all your properties. When I do a trust for somebody, I prepare the deeds because that's the one thing I can do for people. I can't go change your bank accounts. I can't go change your vehicles, but I can make sure that I record a deed for each of your properties and at least you've got those assets in there. So, you know, and it's, you know, when you're talking to people as agents or, you know, whoever's selling real estate, you know, people will think, oh, I named it. I mean, I can't tell you how many times people go, oh, you know, I said it was going to be in the trust, but it really actually, you have to, anything that's got a title, a vehicle, a bank account, and homes, you actually physically have to go in there and change your name on your checking accounts, change your names on the vehicles, and deed the property. Otherwise, you got a trust, but it's not really actually funded. Is what it comes down to. So
Are
then,
there items that Schedule A will not work for that are going to have to go through probate no matter what?
no, I think, you know, anything that you can evidence an intention, you can do the one-time petition, do that. You know, and your personal property, all you have to do is say your household possessions and all that kind of thing. I mean, and that doesn't have any kind of title that goes with it, but I think I can't think of anything off the top of my head.
Well, I think where that would be, become potential problem is as people acquire additional property. If you're acquiring additional property, you're not titling it in the trust and you're not updating your trust to reflect it, then you've got that scenario.
Yes. Yeah.
So that's something to be aware of, people. It's not as critical to update your trust when you're relinquishing property, but as you're acquiring additional property, you know, you want to do two. It's a two-prong. You want to update your trust and you want to deed the property into your trust. But what would you say is more important?
Deeding the property into your trust.
Trust.
Yeah.
Even if you don't, and deeding the property into the trust is a fairly easy, if you have the trust established, process. Like you go as yourself as an individual, as the grantor, into yourself as trustee of your trust.
Yeah.
And yeah, so, and even if you don't update your trust, physically, then you've at least got that. I mean, both are optimal. Updating your trust and deeding it, but priority is deeding the acquired properties into the trust.
Yeah, absolutely. You definitely want to, and if people are buying a property and they're getting a loan on it, they may not be able to put it into the trust. You need to remember that after you're done, and I have people that come to me and they just need a deed. They've purchased a property and they had to keep it in their name individually to obtain the loan. And then we can just record another deed and put it back and put it into the trust. And that's not a problem for lenders. The fact that you go deed that property into the trust, it's not going to hurt your loan or anything. Just some lenders do not feel comfortable with it starting out in the trust.
Any questions about that?
So the auto has to be in the name of the trust to have it in there?
The auto?
Yeah.
Yeah, well, it doesn't have to be, but if, again, and just harkening back, the whole purpose of the trust, it's an estate planning document, so it's what you want to have happen should you pass, die, go to the next place for your heirs. The auto would, if it's outside the trust or any asset that's outside the trust, meaning it didn't get conveyed into the trust, would be subject to the probate. Notwithstanding, well, and it's still going to be subject to a court action if it's not in the trust. If it's at least listed in the Schedule A of the trust, as Carol was saying, she can listed in Schedule A, but maybe not physically conveyed by a conveyance document. For real property, that's a deed. For autos, boats, et cetera, that's the title. And if there's a loan on it, there's likely you're not going to be able to do that until that loan is paid off with the creditor.
Correct.
And then, and bank accounts. And the bank account's going to be a signature card, and you're going to need to provide the bank or the financial institution a copy of your trust or trust certificate. Did that answer your question?
Yeah, and with autos or vehicles and all that kind of thing, you have people that don't want to go deal with DMV, imagine that. If, as you correctly said, if you have a loan on the property or on the vehicle, you can't put it into the trust until you actually own it outright. If all you had were vehicles under 25,000 in value, you can go down to DMV and there's an affidavit that's all you have to probate. You can't transfer vehicles. So vehicles I'm not as concerned about unless if you have a lot of vehicles and they're worth more than 25,000, then you need to go down to DMV. You just got to bite the bullet and you got to put it in there. That's kind of how I advise people when they're, if all you have is a car that's, vehicle that's older, worth 15,000, and you want to just not do it, or and people sell vehicles and stuff. So that's probably my least worry is the vehicles. But yeah, you definitely want to, and you need the bank account. The bank account is another thing that comes up when you're dealing with transactions, because if you have a property in a trust, your check's going to be cut most of the time to the trust. And so you've got to have that account set up, and it makes it easier for your successor trustees if you have a trust account set up.
Right, that's a good segue. So any other questions on that? Oh, sorry, yes.
It might be a little bit unrelated, but can you put an LLC in a trust because the LLC owns properties?
Yes.
Okay.
And you do that by, what you end up doing is you change the ownership of the LLC to the trust. And then what I do is I make the trustees would be a manager of the trust.
Okay.
So you can do that so that you can transfer the LLC.
Okay, so this is where it gets a little trickier, extenuating circumstances. So when you guys are going to take a listing and anybody says the D word, like there's a death, somebody is deceased, please give us a call and give us the address so we can see how the property is currently vested. I had a client, I tell this story, and if you've been to this class before, you're gonna be like, I remember this story. I had a client that reached out to me. She was getting a list of property. The woman's husband had just passed away and she couldn't afford the property, so she needed to sell it. And so the minute she starts talking to me about somebody being not with us anymore, I said, okay, what's the address? Tell me right away. So she's talking, I look it up. I see that the husband and wife are entitled, just as husband and wife. Does anybody know why that might be a problem if one of them dies? Yeah, who said that? Yeah, there was no joint tenancy. There was no survivorship. So vesting matters. And for those of you I know that through the real estate school, you know you're not supposed to advise your clients on vesting, right? And it's a big deal. You shouldn't be advising them. Every title company, including Stewart Title, has a sheet that describes different types of vesting. And, you know, I think we might have time. I'd like to go over this for a moment, even though it's a little bit off the trust beaten path, because it's super important. So again, y'all know you don't advise on vesting, right? There's several different ways you can take title. One's in a trust. We're talking about that one. If you're an individual, you really, as far as estate planning, if you take title by yourself, and you die, and you're just entitled by yourself, that's going to require a probate of some sort. There's not a lot you can do unless you've conveyed and transferred your property into your trust. For two people, there's a few options. So joint tenancy, one, everybody knows joint tenancy, right? Right of survivorship. Sometimes it says joint tenants with the right of survivorship. Sometimes it doesn't say with the right of survivorship. However, joint tenancy is right of survivorship. So as long as it says as joint tenants, there's right of survivorship. Anybody can take title that way. Michael and I can take title as joint tenants. I and my husband can take title as joint tenants. Carol, Michael, my husband, Carol, we can all take title as joint tenants. There's presumed survivor interest. So you don't allocate interest when there's a joint tenancy, but it's presumed if there's 4 people in title, there's how much interest to each? Right. So if one dies, then the survivors assume then now they're entitled 33 1/3, whatever the amount. I didn't do that great in fractions in school, but you get the idea, right? That's joint tenancy. Tenants in common is not joint tenancy. Tenancy in common is you can allocate interest. So let's say Michael and I are buying a property. I'm putting up most of the money. So I'm going to take 75% of the ownership. Michael's 25% of the ownership. Okay. If I take title by myself as an individual and he takes title by himself as an individual, when it's a tenancy in common, then if one of us dies, then our interest is subject to probate and is distributed pursuant to our estate planning. Does that make sense? I can take my 75% interest in my trust, however, and then if I'm the one that kicks the bucket first, I don't require a probate. My successor trustee, and I'll go over that in a little more depth in a minute, can take over and administer my portion of the 75%. It does not affect Michael's 25%. And I'm just using those percentages. It can be 90-10, it can be 50-50, whatever. If people take title as tenants in common, they don't allocate the interest out, then again, it is presumed based upon however many people are entitled that that's the allocation of the tenancy in common, but it does require probate unless the entity entitled as to whatever percentage is entitled in their trust. Does that make sense? Okay. The next vesting is community property. Does anybody know? I'm going to take a stab at who can take title as community property?
Married people.
Yes. So you have to be married to take title as community property. If you take title as a married couple in community property and you die, one or the other of you dies, the estate is subject to that person, it's implied 50-50, and it's subject to probate. Are you going to talk about if there's a homestead? I don't want to confuse, not yet though.
Yeah,
Okay.
I can.
Okay, I'm going to finish and then we'll have you jump in. Because it can be confusing, but that's that. So essentially community property, and the purpose of community property is it includes it can include a stepped up tax basis for married people that file joint return, right?
Yes, I believe so, but I am not a tax.
And neither am I. So that's all we're going to say about that, but that would be one of the reasons why people would take title that way and why it's only available for married persons. And Then the next way you can take title is community properties. You've got your stepped up tax bases with right of survivorship. Then you have the right of survivorship provision in there where one spouse predeceases the other. There's survivorship for the other spouse. They don't need to do a probate to take title to the property as themselves. They both die, then all bets are off and we're back to a probate situation. So does that make sense?
I have a question, so it's curveball. What's the other D? Like divorce?
Yes.
So if you have a trust together and then you get divorced, do you have to both redo a new trust, or is there something you can do to like,
Are you talking about once you're divorced that you like dissolve the trust, how you do that?
you'd have to start all over from scratch with a new trust with yourself?
It would be, I would probably be advisable. if you're
I
gonna
don't
do
know,
that.
I'm already divorced, so I don't really care, but I'm just curious how that would work.
Yeah,
Yeah, well, generally what happens is if you get divorced, you're gonna be deeding properties out of that trust to one spouse
To
or
the
the other.
other, so it doesn't.
So then you don't want to have anything in that trust. That trust is just done. And
So you start a new one.
And you start a new one.
That's what this was. Oh,
Yeah.
Yeah.
Well, good thing I haven't started one yet.
yeah. So did you all already know that, or did you learn something right there on vesting?
And
Good,
I am gonna, so just so it's really clear that if the community property, if you do not have with rights of survivorship, it's 50-50 and that interest really has to be probated. It's not a guarantee, and it's have the right, if you're not holding it as with survivorship, you have the right to convey your property by will to whoever you want to, really, so I mean, it is really, community property's got two little issues to it, if it says nothing, it's not with right of survivorship. But if you want it to be with right of survivorship, you have to say with right of survivorship.
Yeah, and when we get our vesting sheets filled out, and if I have a flyer that says Mark's community property and they don't put the right of survivorship, that's easy for me to say a portion on there. I always ask, is this what your intent was? Because a lot of people, buyers, they're just hurried, they're excited, we're married, yep, we're gonna do that one, we're married, we're doing community property, and they don't look to see what the next piece is. And I will say 10 out of 10 times when I ask that question and pursue that further, it's like, oh, no, we didn't, we wanted the right of survivorship provision.
I knew that from experience. My father just died, but he and my mother had gotten divorced already. And my siblings that never talked to my father, all of a sudden were fighting over the second house. And it was, I didn't want to get involved because I hadn't talked to my father either. So I'm like, I don't care about the house. It's not mine. I don't care. And he had to go into probate. And it was when he started harassing my mom about the house that I looked into the documents, and it was joint. I'm like, he never changed it after the divorce, so the house is yours.
Doesn't.
No need for fighting. Mama wins.
Right.
Interesting.
Yeah, let me talk about that homestead.
Yeah, and then I'll finish my other story that took me off on the vesting bunny trail, but yes, please.
There is an interesting, so I learned about this just a few years ago. There's a statute that provides if a husband and wife recorded a homestead on the property, but they held title as husband and wife as community property, so no survivorship. And this would only work on their primary residence because that's you can only homestead a primary residence. The surviving spouse can actually file an affidavit and be able to get that community property interest without having to go to a probate. So that was a little interesting part of the law. That's what's kind of interesting about the law. I still keep learning things, even though I've been doing it for 36 years. So that is a way to correct the community property issue if they did not put right of survivorship. But again, it's only on the primary residence because
You do it after?
no. No, it's got to be, they have to have recorded the homestead while they're both alive. And then you can go ahead and get that community property interest transferred without doing a probate.
Does everybody know what a homestead is, what it's for, what it does?
Protects you from your predators?
Ish. Basically what a homestead does is, and you have to actually record it on your, and it is, as Carol said, it only works on a primary residence. And it will protect up to, I don't know the exact amount, if anybody knows it, 500 and some $1,000 of equity against involuntary liens. Doesn't protect you for that deed of trust you signed to obligate the property for specifically, but involuntary liens and up to approximately 500,000 plus in equity. But you have to record the document. It's not just that you buy a house as primary residence and then you have that homestead exemption protection. That document needs to be recorded.
Do you suggest that when people do a trust to do the homestead?
When you buy a primary residence, do a homestead, whether you have a trust or not, definitely.
Yeah, I do. You do have, it's slightly different language. If you have a trust, there's slightly different language that you use in a homestead. So I do recommend that you talk to an attorney about that, because if you just use the form that's in like Washoe County, it doesn't differentiate between taking title just as husband and wife and having title in your trust. So there's a little bit extra language that you put in there that, and then it would get recorded after you record the deed to the trust, and you would record the homestead. So like, cause I'll get people to come in and they've recorded it, they'll, record a homestead and then we put it in the trust, and then we do another homestead that references the fact that it's in the trust.
Okay, so back to my story. So this lady, my client, the realtor calls, and I look up and I notice that they're just entitled with no survivorship. So immediately I put her in touch with Carol, and I just said, you need to have your client, if she doesn't have a probate attorney already, please have her reach out to this lady so that they can start the process, because this Mrs. didn't have the authority to sell that property, at least not the half that was her husband's, because she only really owned half of it because there was no survivorship. Does that make sense? So had they gone out and listed the property in just the Mrs. name and gotten an offer, and then we would have eventually found out, right, that the Mr. had passed. They didn't even have to, Carol had to petition the court to even give Mrs. authority to sell the property. So that would have put them back even further time frame wise had that happened. It was just, luckily the conversation came in. She said the D word. We started looking and we connected them immediately. Because we connected them so quickly, it probably shaved off a good 4 to 6 weeks of pain. At least that would have just depended on how long the house was on the market before it would have gotten into contract. Because again, by the time it gets into contract, under a circumstance where you're not doing a pre-open and we get the prelim or the commitment, and we see that there's more than one person, and we start asking that question, had I not been made aware of it, before, you're down the road ways at that point, who knows how long. So this lady, and there was a homeowners association, there was a loan. It took a while. This probate, I feel like we started in July, bless you. And I can't remember why, but there were some complexities. It didn't close till January. She was delinquent on her mortgage payment. The HOA was threatening foreclosure. And that would have just pushed it out even further. So really important stuff to know. How many people in here order property profiles when they're taking a listing? If you don't, please, and look at them and review that, because that's really quick. We can do a commitment or a prelim takes a good 3 days at least typically. And that's depending on how involved the search is and how many other transactions are going. Our customer service department can push out a commitment typically an hour. So you can get that information available to you fairly quickly. And if you're looking for something specific too, like if you have word that maybe there's some other little shenanigans going on, let us know that, and they will look a little further as to if there's some other things to look for. So, okay.
I need to open a property profile for you today.
You do?
Yeah.
Okay.
I got an offer, and I said it, you did it already.
You did.
So it's on your name.
Okay. Okay, you said it. Yeah, okay. Oh, you're funny. Okay, so any other questions on that right now? We did close that one. It was a kind of a happy ending, but it took a while too. Do you remember who it is that I'm talking about? I don't remember the
I can't
name,
remember the
but
name, but I
would
do
say-
exactly remember. And I mean, and it's really hard, you know, I get these situations where people come in and, you know, she's just lost her spouse. She can't afford the house. It's, you know, and you've got all these people coming at you, the HOA and the loan. And that's why it's super important if you're helping somebody to catch it right, you know, get that property profile, catch it right away. Because what I did is I can go get her appointed as a special administrator. And with that authority, then a person can list the property. I mean, one of the things that I request specifically is that the special administrator have the power to be able to list the property. And then you can list the property immediately. And then when you get an offer, you give it to the attorney and then we file a petition to have that offer approved. And it, you know, we can just move it right along, you know, so you don't have any lag time.
Any more delays than are already there.
Yeah.
Because of the court process, the probate process.
Yeah, but it was, you know, it was super, super stressful for her. So, yeah, that's to get it, jump on it.
Yeah, jump on that D word. So extenuating circumstances. This is where it gets trickier. And again, that when you know somebody calls you, they're the heirs or their parents were in trust and they're now deceased. So we talked about the basic components of the trust, which are the grantor, settlers, trustor, that those are Carol and I are two people. We're going to transfer our assets into the Carol Roberta Trust. And you can make whoever you want the trustee. So you don't have to be the trustee of your own trust. I can appoint, we could establish a trust and appoint Michael as the trustee of our trust. That gives Michael all of the signing authority essentially, typically, because the trustee powers go to the trustee. You don't usually see that until somebody's deceased, where the original trustors are not also the trustees. And then usually that will typically be if it's a completely different entity, like a bank or some, you know, a financial institution will sometimes take over as a successor trustee in that scenario. But again, very important for us to have. The other thing, when I said, and I sort of breezed by, what does a title company need? A copy of the trust or the trust certificate. So the trust is the full document that has all the information. We don't want to get into your client's private personal business, and it's a sensitive situation, and it's extremely sensitive for some people. The really good attorneys that do this do the trust certificate, and the trust certificate's usually going to be a 3 to 10 page document that just gives the quick down and dirty for what a title company or a financial institution needs. You know, we need to know the name of the trust. We need to know what the trustee powers are. We need to know who the trustee is. It needs to be signed and notarized. That's all we need. In the absence of that, if for some reason your client or you don't have the trust certificate, we don't need the entire trust, but the portions that we do need are going to be the face page of the trust that talks about who the trustors and the trustees are and the name of the trust. We're going to match that up to what the how title is vested. We need the section dealing with the trustee powers. Trustee powers are important. That's what tells us who can sign on behalf of the trust and what the authority is. And then we need the signature and notary page. Yes, ma'am.
So I have a guy that wants to sell land. He's a power of attorney for a lady who has not passed away, but she's a little crazy. And I don't know if she's mentally insane, but she's not paying things and he's trying to sell a piece of her land. If he's the power of attorney for her trust,
What's his relationship to her?
it's a good question. It's a new thing. I'm just trying to figure out. But I'm not married,
Okay.
but power of attorney. So what's the difference of that and trust or?
Totally different, completely different. That's a great question. We're going to talk about powers of attorney, but anytime, this is another example. Anytime you have somebody that has power of attorney for somebody, let's talk about it because the title company may not accept it. And then if you have something that there's somebody that's elderly or somebody there's mental incapacity, we're going to dig. I mean, because we are in a position that we have to look out for the title policy that's being issued to a buyer, but we also have a responsibility, a fiduciary responsibility to people that may lack capacity as well. So we have to be sensitive to that. So powers of attorney are not our favorite. There is a slide in here where we'll talk about it, but I'm glad you brought it up right now when we're talking about the trust. So we're going to talk really quick and come back to extenuating circumstances. Part of the trust packet that Carol and the estate planning attorneys create, they create powers of attorney, durable healthcare powers of attorney as part of that packet. That does not mean you can use that power of attorney to sign for the trust, that you can appoint that person to sign for the trust. The trust itself will determine whether or not you can use power of attorney. So if you have a client that comes to you and says, well, yeah, we're in a trust, but I have power of attorney. Okay, the title company needs to trust. First thing we're going to do is look at it and see if that trust even allows for power of attorney. Most trusts do not. Some are starting to a little more often, but most trusts do not allow for power of attorney. What happens is people get confused because they have powers of attorney in their trust packet that they can use that to sign. That's not the case necessarily unless it's been
Right, especially if they're
specifically provided.
alive, like, she's
Yeah.
still alive.
Yeah, and sometimes, it's hard there's different reasons. And we're just going to want to drill down and get very comfortable that the reasons being presented are actually
Okay.
what's transpiring. So keep in mind, and we'll talk about powers of attorney a little bit more, but with regard to trust, and I'm not saying argue with your client, just say, if they tell you that, just say, yeah, we just need a copy of the trust to get to the title company so they can let us know everything they need. And then we'll do that. And we're happy to have that conversation with your client. We're the ones that are, make us the bad guy. We're the ones that are kind of the arbiter of that at that point, right? You aren't. Just connect us with your client and then we'll boss them around nicely. But, we'll do that.
I have one more question, I'll be quiet.
No, you can, no, this is great.
I have another client that somebody died and they are both on the assessor. And it's not going to probate, I know that much. But how long does it typically take to take that spouse off? If they come to you as an attorney and they say, we need to take this guy off.
Yeah, well, if they held title as joint tenants, so then you'd end up filing an affidavit of surviving joint tenant. You need to have the original death certificate to be able to record that. And then it's just a matter of how quickly the attorney or whoever's preparing it can get the affidavit prepared. And then it gets set down for recording. And I mean, it can be really quick.
Okay, good.
Yeah.
That sounds way less complicated than signing somebody else's land.
Okay, so in the case somebody's deceased, please let your sellers know that we will need a copy of the trust. We will need a copy of the death certificates and we'll need the original certified death certificate. So if for some reason, really the original people died out of state, then we want to start working with, if they don't have copies, with that state's or county's Department of Vital Statistics to get that original certified copy of the death certificate. The other thing is, I just thought about it. It went about this. It's cold in here. My hands are cold. It's making my brain freeze. The other thing, just as a quick point on the components of the trust, trust or trustee, then you have beneficiaries. That's another big part of the trust, right? Those are the people that receive benefit of the assets when the original trustors are deceased. The trustee and the beneficiary or the successor trustee are not necessarily the same. Oftentimes they are, but in many cases, you may have 3 or 4 kids. You're not necessarily going to make all 3 or 4 of your kids all your successor trustee. The purpose to appoint the successor trustee is they take over the trustee powers in the event of the original trustee's death. So again, back to my illustration, Carol and I have a trust together. Let's say Michael is our successor trustee. He doesn't have the right to sign anything while we're alive, but when we pass, he takes over and he becomes the successor. He may not be the beneficiary. It might be Kyla and Kira. They might be the beneficiaries. He's just signing to distribute and administer the trust pursuant to my and Carol's wishes to our beneficiaries. Alternatively, he may be the beneficiary, but they aren't necessarily one and the same. So the successor trustee takes over the trustee's powers upon the death of the original settler and trustee. Does that make sense? Another important thing to be aware of and let your client know is that once the original trust or trustees die, their socials die with them. Most trusts are set up under a person's social. So the successors have to get a tax ID number established, a separate EIN. It's pretty easy to do. Anybody can do it. You can go on the IRS website, there's a little tab that tells you how to do it, and it will assign a tax ID number. Some people, if they have an accountant or CPA that's helping with the estate, the accountant will usually obtain that, but people that don't have that, and this is non-negotiable. They have to do that, and that's the tax ID number they need to use. Because Michael doesn't want to come into title and sit down and sign a bunch of documents and use his social, right? And have the sale reported under his social. It doesn't affect him financially. He's just doing the signing. So we need this established and communicated to us. And then to Carol's point about how proceeds are paid when a property is vested in a trust. So Stuart's position is if you are in a trust, your clients are invested in a trust and you don't have an account, they should have one, you should have one. Anybody that has a trust should have at least one account set up in their trust. But if they don't, we're not getting any flogging out today. We'll just do an instruction that says that we can transfer the money to your accounts as individuals. But if it's a Carol Roberta trust, then it's going to go to Carol and Roberta's account, okay? As individuals, and we have you sign something and we do it. All bets are off when the original trustees are deceased. If the original trustees are deceased, they have to set up an account in the trust with that tax ID number. And if you're doing transactions with anybody that isn't conveying that or isn't aware of that, it's really important that you need to be, so that you're making sure that your client's aware and protected. Does that make sense? Yes, Ginger.
Question for Carol.
Yeah.
Do you help the clients sometimes? So if we have a client that we're just kind of like, you know what, Carol's a specialist in this area, we're gonna send you over to her. Do you help them set those tax ID numbers up? Is that part of what your services are?
I have a wonderful assistant named Vienna.
Okay, so you
Very
don't.
good at doing that.
That's awesome.
And I mean, it's a super quick process.
It's really easy.
And she will sit down with, one of my clients and just go on the computer and you have the letter like this. And part of the reason why the socials die is and you need the EIN is because usually you've got a revocable living trust is usually what you're dealing with. And when both of the creators die, it becomes irrevocable. So it becomes this entity that's an irrevocable trust. And that is why you get the EIN number.
Could you explain revocable and irrevocable?
Yes, so most of the trusts I create are fully revocable. So the concept is you can create your trust, put your property in, change it, do whatever you want. You can get rid of the trust. It's not, it's not set in stone forever. You can do what you want. So you can add property, you can sell property, you can make changes, go in and you can make amendments, you can do whatever you want. And change your successor trustees, all of that kind of thing. When both of the creators or the sole creator die, you do have a successor trustee, but that trustee has no power to make any further changes. It becomes irrevocable and nobody can change that trust. So you're stuck with whoever your successor trustees are, you're stuck with distribution. There's no changes that can be made. So when Michael comes in, he doesn't get to change anything as a successor trustee. His duty is to carry out the wishes of the creator of the trust and give everything to the beneficiaries as he's been instructed to in that document. And so that's what the differences are. And there are, I do have people come see me because you still might want to publish a notice to creditors. I mean, and there's certain notices you give out to beneficiaries. So it is really good that you have an attorney help with the distribution of a trust and everything that you do after somebody dies. you avoid probate, but there are still certain things that you want to be cognizant of, because Michael would want to make sure that he's given notice to all creditors so that nobody comes back to him and says, you know, we're owed this money, you didn't do your job, and so now we want you to pay us. So, you know, you're on the hook.
I was like, can we bring Patrick in on this part now?
So that, you know, you do still want to work with an attorney. And a lot of times, you know, if everybody's really getting along and say it's just one person or two people, you know, I kind of assess the situation, but if you've got multiple beneficiaries, there are certain steps that you do want to take. If you've got multiple creditors, definitely want to follow up on that. Yes.
What if the successor trustees predecease the original trustee and no changes have been made?
You got a problem.
Do you go to probate at that point? Or?
What you would end up, if there's no provision anywhere for appointing somebody else, or, you know, like the beneficiaries, sometimes you can include in their clause that if there isn't anybody that beneficiaries could, you know, vote and have somebody come in. But if there really truly is nothing, nobody, then you would have to go to court and you would file a petition with the court under the trust name. It's not going to be under an estate, it'd be under the trust name. And you'd be looking for direction from the court as to appointing somebody else.
That was a great question.
Yeah.
I mean, they all are great, but that was like one that.
Yeah, people don't, yeah. So it's a good reason why I tell people, you know, you should look at your trust documents every 3 to 5 years and make sure everything's
Updated.
up to date. Yeah, and I also am a firm believer in trying to get at least 2 names for successor trustees, if not 3 other people. Because you just never know what's going to happen.
Any other questions on that part before we move on? We're gonna actually move the slide. Oh. Anybody ever heard of quiet title? Anybody ever had a transaction where something showed up on the report where it was discussed that a quiet title action would be needed before the escrow could proceed?
Should I talk?
Talk about it.
So quiet title action is something that's created by statute where we can go in and we can clean up title if there's an issue with title. And issues can be created in lots of different ways. One is there could be a deed of trust on the property that was paid off years ago. They're always like years ago, and are almost always. And whoever was the lender under the deed of trust is also deceased. So we have nobody who's going to be able to reconvey that deed of trust. So you're stuck with it on the title. So the way to get around that is to do a quiet title. Another thing that'll happen is I have one now where there's a trust. The title is held in the name of the trust, but the trust never existed. So these people.
I just had one like that not that long ago.
No, people do, yeah. This is my create a trust, or they'll create an entity. They'll decide, I want to hold title, you know, in an entity, and I'll just make something up, and there's really.
No entity documents, no supporting it, no source documentation.
So you've got this name or on the title, and or it could be an individual's name. Sometimes you got an individual's name and they purchased the property years ago, that person died. I have no idea whether there are any relatives, you need to get their name off. I mean, these are all, you could have a judgment filed and you can't find anybody to remove that judgment. So it's any of those types of situations. There's a process where I can file a complaint for quiet title. And you go through a bunch of different steps to do this. And you file the complaint, you serve it on anybody that you know of. Like if there is, sometimes there can be other reasons for quieting title. Let's say people really did start paying all the property taxes, they want to take it over. People aren't cooperating. If you paid the property taxes for 5 years and can show you've been in possession for 15 using kind of piggybacking with whoever's on the property, you're in a situation to file a quiet title action. And so let's say I'm trying to remove a deed of trust, I no longer know where the lender is. I would have to name that lender, that person, and then those persons' unknown and known heirs. You do have to go through as the attorney. I have to show what I've done to try and find that person. I have to show what I've done to try and find the heirs. And most of the time, I can't find anything. And so then at that point, what I do is I have to get an order to publish. And I publish notice to everybody, the brother in the world. And because I'm also trying to get rid of, I mean, for all I know, if somebody could have received an assignment of that, they didn't, record it. I mean, you just don't know. So you publish notice as to the people or the name you're trying to get off, as well as any unknown or Joe kind of people. And then once you have that publication complete, so you served everybody, because it's the way you serve people is by publication if you can't find them. Then I have to do a prove-out hearing where I basically go in front of a judge and I say, this is the situation, and go through the different facts. The judge signs a finding of facts and conclusions of law and a deed or a decree quieting title. Those get recorded, and that is how you clean up the title. It takes probably 3 to 5 months to do that. So, it's one of those disheartening things if you're trying to sell real estate and you come up with this mess, because it's not a simple fix. I say right now, it probably costs around $6,000 to $7,000 to do one. They're not cheap either. And just because there are a lot of hoops you have to jump through, like in addition to, I have to record a notice of lis pendens, I have to send a server out to post on the property. I mean, you just have all these different things you have to do. And so it's not the most fun process for people that find that on their title, but it is the way you can clear up title and then be able to sell the property. Yes.
So I see that happen often, especially with manufactured homes not converted, where someone holds title to the property, but then the manufactured home itself has maybe transferred ownership 5 or 6 times without the actual title of that manufactured home being transferred properly. So you've got people owning the property all the way back to 1991. Places like Carson City usually don't have records that were kept very well. And so you run into the situation where these people need to sell and they're trying to sell the property, but then you're inheriting a manufactured home with no title to it. And so you run the risk of, is it possible when you try to go do a quiet title that things just go haywire and then you get stuck with a manufactured home on a property that you own the land for, but then not the home?
I really don't like that situation. One of my most frustrating things is actually dealing with manufactured homes and mobile homes and the titles and getting them cleaned up. That is just because I can't really do it in a quiet title action. I mean, you end up with a mess. So then you have to deal with manufactured housing and figure out a way to get through that title issue, which is difficult. I mean, I don't have any secrets or anything to really, point you in a great direction as to that. It's a process and it is a mess that people end up in. I don't know. Yeah, it takes a long time. There's no, and just finding the right documents to, be able to deal with that manufactured home it's super difficult. But I don't clear those up with a quiet title action. So you just, it's personal property that's sitting on, basically it's personal property sitting on a real property. The quiet title is dealing with a real property. And then you got to go through some kind of process with manufactured housing to be able to put up that personal property on it. I don't know if you have some.
Nope.
Yeah. The topic we
I try to stay away from it.
Yeah.
Something like that, and we've been waiting for about a year for the title.
I
They
believe
didn't
it.
have a title, so we had to actually go to Las Vegas and actually tried to get the title there. Actually, title has been working on it for almost a year now. Get a title on that mobile home.
What's the action called, or what process do you go through?
You know,
It's personal property.
you just remind us. So actually, it's been about 6 months, and they said they were gonna take care of it, and there was no, it hasn't been. So now that you told me, I'm gonna go back and check it out. But yeah, we actually bought that as just land. And it was just the mobile home on top of it without.
Why can't you go to Vegas, how come Carson City,
Well, they have the main office over there, so that's where they work.
Pacific, what do you do?
Yeah. Have like this little office over here in Carson, but
They don't do anything.
you gotta go back to Las Vegas. And that's where everything goes there, so, yeah.
Yeah, you know, I could transfer title through a probate or something to who we think's supposed to have it, but to actually physically get the title, really get it transferred. I mean, you know, what I can do is really only on paper and in this order, but you gotta go through manufactured housing.
It's a whole other world. too.
Yes, it is.
Tough world.
It is a really tough.
Okay, so any other questions on quiet title? I think you covered it. Another reason to advocate for kind of doing your research ahead of time when possible. So if there's something like this, there's maybe a little more time to start working on solutions. Okay, next slide, please, sir. Okay, do you guys know what deed upon death, or also known as a beneficiary deed, is? So you say don't do them? Yeah, I'm not a fan. They're not as terrible as they once were, but they kind of, the purpose is people use them to preclude, like, in lieu of a trust. So like that scenario when I was talking about vesting, where you have the individual who takes title, they don't have a trust. They may record what's known as a beneficiary deed or a deed upon death. It just basically, it's a document that says, if I die, this property goes to Patrick. And that doesn't really seem fair to just give Patrick the property and you have all the liability, Michael. But we're gonna go with it. And so that's all well and fine, as long as Patrick wants the property, can afford the house payments, can afford the HOA if applicable, can afford everything that goes with it. It might be a great vehicle for some people, but if Patrick wants to sell the property fairly quickly, there can be some roadblocks. The roadblocks have gotten a little bit better of late. It used to be, there was a time, it was 2 years before a title company would insure, because Medicaid had or maybe it was, what was it? 18 months something, and then it went to 3 years. But now there's some new information out. I'll let Carol talk about that. It's a little better, but I'm still a fan of the trust.
Yes, I am too. But there are situations, and then I did have somebody who the grandmother was on a deathbed. She was able to, I mean, she's cognitive, but you know, she had her faculties, but and they wanted to keep the house. So I knew it wasn't going to be a problem to execute the deed upon death, and we got it done like in the nick of time. And so it was a great way to transfer the property in that scenario. But otherwise, what you're looking at, so we, you know, as Roberta just mentioned, basically we were having to wait for 18 months to let everything go through the process of creditors being able to go after the property. So that was the issue is. And let me start from the beginning. Originally, the legislature created the deed upon death. I thought it was really great. I did a bunch of them. And essentially the property would transfer and the creditors were kind of left out in the cold. They, you know, because this is a transfer out of probate. You're not doing, you know, you're not trying to search out any creditors. And so this was an asset, people's generally a major asset that is being transferred and the creditors aren't getting paid. So then the legislature created the right of creditors to go after that property for 18 months. And that created the problem of, you know, a title company's not going to want to insure that because, you know, who knows what's going to happen in that 18 months. Then, most recently, I think in 2021, they the legislature passed a new law that allows the publication of a notice to creditors. And so even though you don't have an estate, because generally, when you can publish a notice to creditors related to a trust, but if you've got an estate, you actually have to have an estate open to a certain point before you're publishing a notice to creditors. Well, they have now given that right to publish a notice to creditors under a deed upon death. And there's specific language in the statute and it references the deed upon death. And you go through and you publish it and you have to wait 90 days. Creditors have 90 days to be able to send a claim in to me as the attorney. And then after that time, all claims are cut off. So essentially, if assuming everything else is looking good at the end of, say, about really about 4 months by the time you get the publication in and you get everything prepared, you could close the property now. It's still not instantaneous, so it's not really perfect. If people can't afford the property, that's not great. There are a couple other things. So I provide that service because generally the title companies want an attorney to handle that because they want to make sure that notice is published correctly. I also provide an affidavit that states that I served Medicaid and I've served any known creditors that my client knew of. So, and we personally serve them. And so I provide that affidavit, I provide the proof of publication, and then I also obtain a letter from Medicaid that states that the person was not a recipient, and so they have no claim. And I provide all of that to the title company. And then there are other documents that they need from the beneficiary under the deed upon death. And if everything is looking good, that transaction can at least now close in, approximately 4 months. So it's a little bit better. It still is not as good as if you have a trust, you're just not dealing with that. But again, there are scenarios where I will do a deed upon death like I just described. I do make it very clear to people that you need to make sure that your beneficiary is really going to be able to handle the property and, be able to pay for everything. The other issue with the deed upon death is if your beneficiaries die before you die, well, then you're still looking at a probate. So that's why you go back to the trust. So that's pretty much it.
Yeah, and again, if you have a client that is wanting to sell, that they've recently taken title to property via a deed upon death, then you want to talk to us so we can figure out where we're at in the process, what the time frame is, see if we need to connect them with Carol or if they have an attorney they're working with. Some, which is different with a person that's still alive and we run a prelim and then we see the deed upon that document is going to show in the chain, but it hasn't activated yet because the original vestee is still alive. It'll just show that, and that would be extinguished on the deed out to the buyer, as long as that original vestee is still alive.
So I do know someone that inherited a property from a deed upon death. It has been about 18 months. Can they sell it now? There hasn't been any notices.
That's a good question. That is going to be a title.
Yeah.
That's
311 or title court.
I'm sure it's clean,
Yeah,
but it's still the law, 18 months and creditors.
Yeah.
it is. They have 18 months, and if nobody.
There hasn't been any notice.
Well, a Medicaid, I think that's 3 years, so we'd have to get a Medicaid waiver.
Yeah, you probably have to get a Medicaid waiver, which.
So could you, likely notwithstanding any other issues that would show, and with a Medicaid waiver, I would say that there's a good possibility, obviously without looking at it, I would be irresponsible of me to say for sure, but it would stand to reason that.
Might have a fighting chance.
Yeah, may have a fighting chance.
Okay, sir, next slide, please. So this is another entity situation, the limited liability company, that if you have a seller that's vested that way, we will need a copy of their operating agreement. and they're articles of organization. If it's a Nevada limited liability company, we can check the Secretary of State's website and get that information and see that they're in good standing. If it's from another state, if that state is accessible online, we can take care of that part. We still need the operating agreement. Again, the operating agreement's like, it's the same reason our title department wants to see that, just like the trust, to see who the authorized signers are. I personally think as realtors, it would really benefit you guys in these scenarios, especially a trust with deceased people and entities, to pre-open those files and get the entity documents to title, because you really don't even know who's authorized to sign your listing agreement until somebody's reviewed that and ascertained that. So I'm not telling you how to do it, just telling you why we really advocate for that pre-open situation in some of these scenarios. That's helpful, because if you start a whole process, we just did it. I just sat in the signing this week where we had, and it was the lady who was vested in her trust. She gave power of attorney to her son. The agent had the son sign the contract with the power of attorney. Once we got a copy of the trust, we were able to ascertain that the trust didn't even allow for a power of attorney, and the son wasn't the successor trustee even. So luckily the lady, we caught it right in time, because they were gonna all be going leaving last Saturday. They came in and signed, and the lady could sign herself. So that was a good outcome on that one. But just things to be aware of, like, so the realtor came to the signing and brought every single bit of her paperwork, the listing agreement, duties owed, all of the goodies that you guys get signed before you even get into contract, and had her sign it, because he didn't have any authority on that. And these sorts of things are definitely important. So some things to be aware of with LLCs. If you have a client that's a Delaware LLC, they are not online, and they require that they be, I think they require payment, and they send the documentation via mail. And part of that, why some people incorporate in Delaware, is because it's not public. You can't just go online, and that's attractive for some people. So, and that's great, no judgment, but it does add another layer of time and complication. We had a transaction where a buyer was he wasn't closing in his LLC, but he was self-employed through his LLC, and the lender was trying to do a last minute verification of employment. And so they needed to verify that the LLC was still active and in good standing, and it was Delaware. So that delayed our closing probably about a week. So if you hear Delaware, you want to start working on that. And if it's anywhere other than Nevada, we just want to look and see if that information is accessible. If you have a client that is not in good standing, and their LLC is not in good standing with whatever Secretary of State, they have to bring it to good standing. And I had a transaction that we closed a couple months ago that ended up being delayed probably at least 6 weeks, because this was I've never seen this. I've been doing this 30 years, and I have never seen this. We went to check the Secretary of State website. It was in good standing. My title manager went to check it in conjunction, because apparently he doesn't trust me, and apparently I can't be trusted. Once I sent him the operating agreement, it was put on somebody had gone in and changed the Secretary of State filing to reflect a different manager than what the operating agreement reflected. So as it turned out, in this scenario, my clients, the sellers, have their LLC. They rent and lease properties to other companies, corporations. This other company who leases space from them, office space from them, went in and changed their list of officers. Apparently, anybody can do that.
Really?
Yep. I think they probably had to pay $150.
Yeah, you have to pay money.
So once we figured out what had happened, my clients, the rightful actual managers and people that, created this LLC, went on to the Secretary of State website, changed it back to them,
paid the $150. Well, then the Secretary of State put it on an administrative hold. We can't close when it's on an administrative hold either. It took, because you got to get the Secretary of State pretty much and God themselves to go through all of the rigmarole to figure out now what's happened. This was a nightmare because apparently this tenant of my client had done this a year and a half ago or 2 years ago. And my client had filed a complaint with Secretary of State previously, and then they went in and they had done it again. So long story short, it initially got with a lot of tenacity and a lot of phone calls, but they don't move quickly. If there anybody who's ever had to deal with, well, any of the state, like even Department of Manufactured Housing, right? A lot of the state agencies, the wheels and there's this and there's the layers and the that. And so it took a while. We finally closed, but I'm just, let us know if you got an LLC, let's take a look. Although again, one day it was fine, the next day when they made the change, it went on the administrative hold. So these are some things to think about.
So on LLCs, if you put it into your trust, does it get recorded for the public to see which trust it's in? So if you have the trust in your name, like Dan's Trust, it's really easy for people to just find who you are and spam calls and credit card offers start coming in your email address. How do you keep that level of security?
Yeah, you can't really. I mean, the thing is you can go on to, you can do a business entity search on the Nevada Secretary of State, website. I mean, or you go to Delaware, I guess. But
Right.
yeah.
I mean, that would be one.
But if you got it, if it's in Nevada, you know, we're gonna be filing your list of managers and you're gonna see that, you know, it'd be you as manager of your trust, and that trust name is gonna be in there. So, the operating agreement is not online.
No.
So they don't necessarily know the ownership per se. You would know who the managers were.
You just wouldn't want to name your trust Dan Pez's Trust. You could name it whatever, right? You name it, if the manager of the LLC is a trust, what shows on the Secretary of State website as manager is going to be, I don't think it's necessarily going to even required to show you as trustee of the trust, it'd be just you, or just the trust.
It'll show the managers' names. So it'd show your name.
But if the trust is the manager.
No, the trust, it can't be the manager. It's got to be, a person's got to be the manager. A person's the manager as trustee of the trust. The owner of the LLC would be the trust, but you got to name a person to be the manager. And I name the trustee as trustee of that trust. That's usually how I do it.
I have to look at that, because I've had a couple I've looked up and we can't figure out who it is. Yeah. So.
But that does bring, one of the things I do find too is that people create their own LLCs. They often won't have an operating agreement. So you need to keep, that is another reason why you want to get the documents right away for if you have an entity that owns a property. So you can see what they've got, because people do it themselves and they'll, I'll ask them, why do you have an operating agreement? They'll be, because
a lot of people don't have operating agreements for
Yeah, how do
trusts.
you go about getting that? I've been asked that recently.
you gotta create it, or pay an attorney to create it and do that. And I run into that being a problem if you are deeding property from individuals into an LLC, and to avoid the transfer tax, you have to have the exact same ownership, and you have to show ownership in the operating agreement. And people will not have an operating agreement. And then I can't do that unless we'll create an operating agreement, and then I can send it down to the recorder's office, and then everybody lines up.
And you need an operating agreement to go from an LLC to an S corp as well, right?
Probably, yeah. Yes. Creating some kind of an agreement, yeah. So just things to keep in mind.
It's on the original application, it's just people miss it because no one knows what they're supposed to get from the application. But, like the last page shows like all the fees for different things, and it's on there. Just be afraid to select it.
The other thing to think about with these too, and this is with trusts too, but when,
what we're looking for in the operating agreement, you guys may be working with somebody that says, well, I have the authority to sign. That's okay, great. The title company just needs your operating agreement so they can substantiate that, right? So, and oftentimes we get the trust or the operating agreement, and that's not the case. You know, there's maybe 7 people in there, and maybe that because how the operating agreement is set up, all 7 people are required. Or maybe it's not that way. Maybe there's 7 people in there, but only 1 person's required to sign, or only 2 people. However that agreement is established is what we follow. We're not like trying to make your clients go crazy or trying to make life harder just because it's fun. We ask for the documentation, and whatever your client's source document is depicting is what we are going to come back and say, this is what's needed. And it's based upon that documentation. So, and different trusts are going to behave differently. Different operating agreements are going to behave differently. Again, like I said, you may have a 1-person LLC, that 1 person signs. You may have a 10-person, but only 1 person signs, or you may have a 10-person, all 10. We are just going to basically parrot the requirements of the agreement that your clients established. And that's, you know, because I know it gets frustrating for people. They're like, whatever. Now, that being said, there's more than one way to skin a cat. We're not trying to make people's lives harder. So in that situation, we have one right now where we had, I had 4 people, siblings, that were in an LLC selling a property, and 2 of them were local, and they really didn't want to have all 4 people sign. Although the operating agreement did require the signature of all 4 people. However, we can think outside the box a little bit. We just said, we prepared a document that said that the other 2 people signed, authorizing the 2 that were local to sign everything. They got the one thing, they got it notarized, and then we just have the 2 people sign. So just because it says one thing doesn't mean there isn't something we can do to have a workaround that makes it as convenient as possible for your clients. But again, your clients, they create these documents. We are just holding their feet to their own fire and to protect the title insurance. So does that make sense? And the other thing on a trust, as Carol was saying, for people that do have an LLC where the trust is the manager, we're going to require both the trust and the LLC. Does that make, you know, just again, to substantiate, to drill down who actually can sign. We're not trying to, it's all private, or we have lots of firewalls that we keep everything very confidential. All of our files are shredded upon close of escrow. It goes into our document repository, but we do require that to, again, protect and confirm. So, any questions more? No? Okay. Okay, so Carol just touched on this. Real property transfer tax, everybody knows what that is, right? That's the state's take on the sale of a property in the state of Nevada. Different counties have different amounts. Washoe County is $4.10 per thousand of sale. I think that like Lyon and Douglas and Carson are $3.90. You know, it's not a math test, but that just is a, you know, for purposes of illustration. Anytime there's consideration, transfer tax is required, right? So on the sale of a property. There are a few exemptions. There's a spousal exemption. So for spouses to deed each other on or off the property without consideration, that's 0. There's no transfer tax required. There is, as Carol said, for your investor clients and people that are, they have to, let's say they have to take title as individuals, and then they want to put it into their LLC, the property. As long as they can demonstrate, like Carol and I own a property, now we're going to transfer it into our CNR LLC. As long as we can show the recorder with our operating agreement that we are the 100% owners of the LLC, we can transfer it in without transfer tax. And there's no consideration. That's the other component. That's, I think, an exemption 1. There's 10 exemptions, I believe. There is no exemption to transfer, and that works for a corporation too. Let's say Carol and I have a corporation, not an LLC. We want to transfer from ourselves to our corporation. We can do that without transfer tax. But there is no exemption to transfer out of a corporation back to us as individuals for an LLC or a corporation. You pay transfer tax and you pay either the most recent or they base it on the assessed value, whichever's higher, not less, even if there's no money being transferred. Does that make sense? I mean, I don't know that that makes sense, but does that make sense? So there is one little loophole to that. Anybody know what it is? If you have a trust. The number 7 exemption is a very friendly exemption that you have to have a trust and there has to be no consideration. So people, including your investor clients, probably definitely if they're a lot of people put their properties, their rental properties, et cetera, into LLCs. But if they have to go back and forth for whatever reason, financing, change, whatever, if they are trying to go back again to themselves as individuals, they're going to have to pay transfer tax. However, if they have a trust and there's no consideration, it's exempt. It's called a number 7. And the number 7 exemption says any transfer to or from a trust without consideration is exempt.
Lucky number 7.
Yeah. So another good reason to have a trust, especially from an investor standpoint.
So if it's any transfer, if you're transferring it from a trust to a different buyer,
You can try it, but if there's any money involved, then no, not a buyer. It's no $0, no consideration. Yeah, then, yeah, if there's a buyer, then it's all bets are off, like if there's a sale price. So that's a good little trick. Sometimes we end up doing a few deeds in certain scenarios to save our clients some money. The other, obviously, this is another important one that it's called an exemption number 5, which basically covers spousal and also first degree of consanguinity. So you can deed parent to child and child to parent, even with consideration is the difference. So I can sell my property to my son or either of my sons for however much money and I don't have to pay transfer tax. And they can sell it back to me. That doesn't apply to siblings, doesn't apply to cousins. It just parent to child, child to parent. But you can have consideration in that scenario. So good to know, to be aware of. Any questions on that? Anything you want to add, Carol, with that?
That was good.
Okay, so powers of attorney. If you have clients that they come to you and they're like, they have these clients and that they want to use a power of attorney to sign. First rule of thumb, most title companies we would prefer to prepare our own powers of attorney and have your client sign in our office. Now we realize that's not always, going to be the situation based upon maybe the reason for the power of attorney is the person's out of town or whatnot, but then we can use a vetted notary. But we would still be preparing the document. It's not required on everyone, but that's our first preference and that's the cleanest and best way to get a power of attorney approved. Any power of attorney transaction is going to be subject to our title department's approval. And I feel pretty comfortable in saying any title company that's going to be the rule of thumb. So if that doesn't seem to be like that's as convenient for your client as they would like it and they already have a power of attorney, please get a copy of it to us so we can review it. I'm going to tell you that title's always going to ask why. Why are we using a power of attorney? And that's just kind of that's a good question to ask. If we have a situation where somebody is lacking capacity, we're going to want to dive a little further into that. And I do want to take a tiny little, just an off ramp on this freeway, because you go back to talking about a trust. And if you do have the situation where somebody's trying to sell the property, I see this a lot where I have transactions where original trustee is still alive, but they are now maybe having some memory issues. They're in a care facility and the heirs are trying to sell the property to pay for the care. So that can be kind of tricky. Because now we're asking our title department to approve that the successor trustee is going to take over the signing, but the person's still alive, and that the reason is that person is mentally incapacitated. And so it can be a very frustrating prospect for the clients, for the public who think they've covered all the bases. And then we step in and start saying, well, we have to do this and we have to do that. That being said, it is just the reality of those situations. Most trusts are going to have a provision in there as to what is required on the incapacity of the trustee. And most that I see require 2 doctor's letters. If you are asking our title department and most companies to accept that the successor trustee is now taking over in this situation, we're going to want the copies of the doctor's letters to review, as well as, of course, the copy of the trust. So those are things to just be aware of. That, unfortunately, that scenario becomes a little trickier than just even the death scenario situation. We try to work with people as much as possible. We just closed one last week. The mom has some memory issues. The daughter, she added the daughter to the trust in recently, like as a full independent signer. But the way title was vested was in just the mom's name as trustee of the trust a few years ago. So the title department said, well, the mom's going to join in the execution. She's got to add somewhere somehow. And if not, why isn't she? So we worked it out in this situation where we just had the mom sign 2 things, the deed and an authorization for the daughter to make our title department happy to sign everything. And that worked out in that situation. But again, these are things that the sooner we can start working on that, anything unusual, the better, because then we close pretty shortly after the mom and the daughter signed.
Good.
Yeah.
My land guy and the
Yes.
house lady, would that work for them? Like if she notarized something that said he has power of attorney to sign for her from now on type thing, and she's still present?
It depends on how the property's vested. We want to look at that and when, like, crazy how. Crazy, she's just kind of cuckoo, or she know what she's doing, because that's,
I'll let you know soon.
yeah.
We'll ask her.
So with powers of attorney, kind of the same thing. We're going to want to know why. And it's our goal to try to be as accommodating as possible and yet also stay within certain lines that are important to stay within for everybody's benefit. If we say that we are going to accept your client's maybe existing power of attorney, please let them know we have to have the original. We don't have to have it for very long, but we have to see it and record the original. Now, if there's a couple different ways to do this, if your client's local and they just want to run in with it, we can just say, take it, upload it, record it, done, give it right back to them. If they're out of town, then we need to figure that out. Because a lot of people, as you know, those powers of attorney can be very important and they don't want to give up the original. So those are conversations we need to have to see what the best course of action would be. If there's a steward title that they could go into, we definitely will try to work with the clients as much as possible. Again, it has to be notarized and we need the original for recording of because we would have to record it, and anything that has to be recorded has to be notarized, as I'm sure you guys are aware. Anything else that you want to add, or any other questions on powers of attorney?
Yeah, nothing really, just that, well, actually, there is one thing. One thing is that, when somebody dies, the power of attorney dies with them.
Oh, that's a good point. Yes.
Yeah. Because you'll have people, I'm sure I have people that will call me and they'll go, oh, well, I had their power of attorney. So, can't I just do this? Can't I just sell the property? And it's no, when you die, your power of attorney is gone.
So what is the purpose of a power of attorney? Like if you're incapable?
Yes, so the purpose of a power of attorney is if you generally, so what I'm doing when I'm doing estate planning is I would want a financial power of attorney and a healthcare power of attorney. And the purpose of that is if you become incapacitated, you have somebody who can handle your finances and you have somebody who can make decisions for you as to what you would want to have done with your health. And if you don't have this and somebody becomes incapacitated, then you're facing a guardianship. I mean, I had a woman whose mom suddenly had become incapacitated. They needed to sell her house and, there's nothing I can do at that point. If they're incapacitated, they can't execute a document appointing somebody as their, attorney in fact. So I do use that as part of my estate planning. And it's a great tool. There are just some different nuances when it comes to whether the trust allows a power of attorney, what title company is going to need in order to be able to feel comfortable with using that power of attorney. It still is a great document to avoid having to get a guardianship for somebody. Yes.
I know there's different types of powers of attorney, like which ones would be honored with the title company? Like all of them? Because isn't there like 3 or 4?
Well, we prefer a specific, and when it says specific, that means specific to the property. So
Okay.
we prefer something that's just specific to our transaction. And so if it's a situation where we're preparing the power of attorney for your client to sign, and then we get it signed, then we're all set with that. A general power of attorney would be the other power of attorney that we would use, that we would consider accepting, as long as there's language in there that's appropriate to what is being asked of us, which is to allow this person to sign for this person to sell property. And maybe other things too, but at the very minimum, it would need to have that language in it. And again, just keeping in mind, just kind of repeating that part about the trust, people that say they have power of attorney with each other with the trust. The other thing that can happen with a trust is there might be 2 trustees, but your client may tell you only one of them needs to sign. And again, we'll ask the trust, but the title department's always going to ask, well, why isn't the other person signing? Even if the trust allows for that, that'll be the question. So
It's always better to have the actual person sign.
mhm.
The thing is you just don't get into any issues, like I had a case with siblings and their mother had executed a power of attorney to one sibling. He used it to transfer the property to himself, which is always just fun. And
That's called self-serving, but anyway.
well, it's self-serving, but she did also sign a document that said that he could do that. I don't know, it just get really messy.
They're siblings.
Yeah,
Mhm.
oh, yeah.
But on the bright side too, where powers of attorney can come in handy and be good is if you're taking a listing and like, let's say somebody's in the military or that one of the owners or the owner is being deployed, and reach out to them. Let's get that power of attorney. Let's get it signed ahead of time. We will prepare it. It will be specific to the property. They'll come in and sign with us, or if they don't live in Reno, then we will set up our vetted notary to go to them to get it signed. And then you have that. A lot easier than trying to get things notarized out of the country. And again, for those of you who've ever had occasion that you had a client that, oh, by the way, we're out of the country, access to a US embassy and a notary is not like going to a UPS store. It's like you got to make an appointment. It's, I don't know, like our embassies here are on bi-coastal, so they're not like that in other countries. It's the same thing. It can take hours to get there, days or even weeks to get an appointment. So when you are talking to prospective clients or sellers and anything about going out of town, and especially out of the country, let's talk about ways to mitigate delays. And there are ways to do it. And a power of attorney is one of those ways. May not work if they're in a trust and it doesn't allow for a power of attorney, but let's just take it one step at a time.
There's just nuances.
Yeah,
there are
lots of things. You just want to cover the bases as much as we can. And we can do that with communication and just that information sharing.
Yeah, I think the big takeaway is start in advance. Get your property profile, set up your relationship you know, and then know how the transaction is gonna go and then get as much information to escrow officer to
Right.
be able to look at it, so their title department can look at it. Because you'll be miles ahead, because then otherwise I get a phone call and I'm trying to fix things and everybody's upset and they're stressed and they're, you know, it's just, if you handle it ahead of time,
Mhm. Yeah, for sure.
you know, so that you're not in the middle of a transaction already and then have an expectation of closing like in a week, which that happens. And it just is really, everybody's upset then.
Mhm. Other questions?
I have a crazy scenario. So there's some friends in Sacramento. They have a trust in the county, but it looks like their title is still just joint tenancy with just the couple. But with the trust, they added the mom from the county, but it doesn't match up. But the mom had a bunch of medical bills and put like the house as her home payment. Is there any way for that couple to not have issues with that in the future?
They're all on the house?
So in the trust, the actual title from just a quick search is just the married couple. But then I looked on the county website and it said that for all three.
I would say the county website's probably demonstrative of the condition of title at the moment. They're probably all on there.
Okay,
Yeah.
And
so Laura,
well, I mean, I don't, you know, basically if you're in title on a property and there's like judgments and liens and they can lien the property. And the minute somebody takes title of that property there, that's kind of happens. And another thing just to point out regarding like titling and vesting, joint tenancy, if somebody's taking title to a property and there's two, like there's somebody, a group or a person in their trust, or persons in a trust, and somebody else that's not in the trust and they're taking title together, you can't have that there, can't do joint tenancy. That totally defeats the trust. You have to allocate the interests of whatever interest the people in the trust are allocated as to their interest, and then whoever's not as part of that trust has their own, and then it creates a tenancy in common. The two trusts would be two separate allocations of however, you know, the parties want to do that.
Carol, what's your information so we can all do trust today?
Oh, sure.
I think you might hear.
Yes, so I have my own practice. My office phone is, I do have some cards too, 775-337-0773. 775-337-0773. And then my email is my first name, Carol, and I have an E on the end of Carol, so it's CAROLE @lawofficepope.com.
Law office, what?
Pope, as in the Pope, as in the Pope.
P-O-P-E.
P-O-P-E, yes. Big thanks, yeah.
.com.
.com.
As a new agent, would you not recommend doing probate sale? Buyers on side as a new agent?
I don't know that I would say I shouldn't do that. I think you really, you know, I've walked people through the probate process that taken on a sale and then they're first time, because there are things you need to know. I mean, if the sale's gonna be, needs to be approved in court and is subject to overbid, you wanna make sure that's in your listing. You want everybody to understand that, you know, we've got your offer, but it has to go to court, it has to be approved. There will be overbids, and generally, you know, if the property's selling for over 100,000, your overbid price has to be at least 5,000. So, you know, if you've got an attorney that on the other side is willing to help you and kind of answer your questions, you can do it.
Can one thing I forgot to touch on, because we started it in the beginning and then I didn't. Can you talk briefly about the two, what the type of probate that you're discussing with him and an IAEA probate?
Yes, so the two ways you can end up selling a property. You can sell a property through the probate, like I was after you've done. And if you do it during a regular probate, it will be subject to court approval and overbid.
Okay, because I was just wondering, because I was in a situation where I was gonna do this, there was no conditions, it wasn't subject to court approval or anything. And the lawyer had told the seller that I didn't have enough experience and that they should go with somebody else.
That's the attorney's issue. They want to use your name.
Your seller can pick whoever they want.
And then there's another way, if I get somebody,
Meet the attorney.
if I,
Go in and meet the attorney. Introduce yourself.
yeah. There is another way that you can sell property, and it's under an independent administration. And that, so I can have somebody appointed under a summary administration or a general administration, and I can have them have independent authority. And what that means is that they can go ahead and list the property, they can accept an offer. And then what you do is you send out that offer to the beneficiaries under the estate and give them the opportunity to accept or object to that sale or do nothing and just let it go through. And you basically give them the information as to the sale. They have a certain time period if they want to object to it, and then you let them know when it's going to close. And then you can go ahead and close that transaction. It is not subject to court approval. It is not subject to overbid. They're just, it depends on what's really going on in the estate, whether I use that or not. There are just different factors, kind of how people are getting along, whether I need to get a special administrator appointed, because if I get a special administrator appointed, I generally am not gonna, and they accept an offer right away, I need to file a petition to probate and a petition to get it approved right away. So I can't really, in that scenario, go into an independent administration. If I have plenty of time to start the process, I can get the independent authority. Does that make sense? Any questions?
So independent authority would work even if it's fully probate, and you wouldn't have to do the court steps and the overbidding.
Right.
If they get along, everyone's happy, and they'll just give it to themselves and fight.
Right.
Got that.
Yeah, I mean, like I said, it does depend on that. It depends on kind of what the dynamics are of people. And maybe it's a property that is gonna be something that is gonna really be subject to overbid because it's a lower priced property. It is, it needs work on it, and you can, in the right scenario, get some overbidding going. And that can benefit the estate rather than just going out and just trying to sell it and you get an offer. Because we have, in Washoe County, we have certain people that fix up homes and they definitely watch the probate sales and you can get a bidding war going. So they're just different factors, but not every probate sale, if you get the independent authority, then you can avoid having that court approval.
In, let's say, recent last couple of years, especially since COVID, I haven't seen a lot of overbidding happening for homes as much as I used to see it happen all the time. Do you think that's just because of the Zoom calls that they're doing now, or people not able to find out about these homes? Or maybe you noticed something completely different.
She knows that too.
I think it's not quite as prevalent because we're not in person, but it still happens. I mean, when you get those properties that are in that right price point and have, and need to be repaired, you still get the bidders. And I think part of it also is just how our market is going. I do feel like that most of the time when I take a sale in to be approved, and it's like, say, the 400 to 500 or up, generally the sale I'm taking in is really what it's worth, and people aren't overbidding. It's more of those lower end properties that you're gonna get the overbids. And even when we used to be in person, the market does go through cycles, whether you have overbidding, whether you don't have overbidding. There was a time years ago when we were in person and the market there was no overbidding. So it's a little bit of both. It's a little more awkward doing the Zoom telephone call to get the sale approved.
Do you think the process that we typically have now is efficient, where we put a home out for sale, somebody goes and makes an offer on it, we get this contract accepted, and then it goes to court, and then it goes for overbid. So the person who put in the initial offer sometimes doesn't get it, and if they're not experienced or the agents don't know what they're doing, they've already started inspections, all this stuff, and then it just comes to be a total shit show.
Yeah, but I don't think there's really a way around that, you know? I mean, because you do need to, I mean, that's just the way the statute's written, you do want to get the sales approved. You know, I don't see that that's really gonna change. And you want to make sure, you do want to make sure that you get the best market price you can receive the property in probate. And you never know whether, like, you know, somebody lists the property with a real estate agent, are they experienced, are they experienced enough to know how to really set the price for the sale of the property? And that's kind of the insurance of, in a probate is taking that sale and putting it out there to the public and letting it be subject to overbid. And they've done it for so long, I just don't see that changing.
So you think it's efficient, you think it does its job at creating the best possible price?
I do.
Gets it done.
I do, and I've seen that. I've definitely taken sales in and gotten the best possible price because it goes up, because I do have overbidding going on. So it is a little cumbersome. You do need to make sure, that's why it's so important to make sure it's in your listing, that everybody understands it's subject to court approval and overbid. And that you do have to be careful with the inspections that go on, and make sure everybody's really aware of that. Also, what's really important to understand is that if there is an overbid and it is a new buyer, so it's not the original offer that came in, the agent split the commissions. Yeah, I mean, I've seen that create problems. I always am really, and in that scenario, I definitely announce on the phone that, and everybody understands, the commission's gonna be split by, and that makes sense too, because the person who's brought the offer in has done the work, but then you've got somebody else that's gonna be doing the completion work, so that's why it gets split.
I'm out of questions. Thank you.
All right. No, questions are great. Any other questions? Thank you guys so much for coming and the great questions and your time. Hopefully everybody learned something. Yes.